everyone. Welcome. I'm Linda Zarrilli, Director of the Center for the Study of Gender and Sexuality. As some of you may know, the Center has initiated a series of talks this year around the issue of sexual violence on college campuses. Before introducing our first guest speaker, Professor Janet Halley, I'd like to say something about the issues before us. I'd also like to thank the law school and especially Professor Jeff Stone and Dean Mike Schill for their help in co-sponsoring this important discussion. Thanks too to my colleagues at the center, Lauren Berlant and Kristen Schultz for their help in brainstorming about the series that we're planning for this year, and also to the staff of the center, Jean Olson, Sarah Tui, and Tate Braza for realizing it. In April 2014, a White House task force issued a report on how to protect students from sexual assault. The key first step in starting a successful prevention campaign, it was argued, is to gain better knowledge of the nature and extent of the problem. The report estimates that 1 in 5 women is sexually assaulted in college, most likely by someone known to her, yet only 12% of the assaults are reported. Such numbers are surely important to any attempt to combat sexual assault. But is the problem that confronts us really a lack of facts? Consider Washington Post columnist George Will's, I know, now infamous remark about how the report inflates the numbers and does not make simple arithmetical sense. Quote, if the 12% reporting rate is correct, the 20% assault rate is preposterous. Mark Perry of the American Enterprise Institute notes, for example, that in the 4 years, 2009 to 2012, there were 98 reported sexual assaults at Ohio State. That would be 12% of 817 total out of a female student population of approximately 28,000 for a sexual assault rate of approximately 2.9%, too high but nowhere near 20%, unquote. Before we ruin the lives of more, quote, innocent young men at grave risk of being accused, now that being a rape victim has, quote, coveted status, argues Will, we should check our numbers. Okay. Will has clearly made himself an easy target, but his comments about the, quote, pesky arithmetic that the Obama administration chooses to ignore raises the question of the facts in an acute way. Even if one is not exactly confident in the objectivity of the American Enterprise Institute, what are the limits of battling this out at the level of the numbers of real rape victims alone, or any other related facts? Perhaps we already have all the facts we need. What we know is not always what we acknowledge, to borrow an important distinction made by the ordinary language philosopher Stanley Cavell. Quote, from my knowing I am late, it does not follow that I acknowledge I am late, otherwise human relationships would be altogether different than they are. One could say acknowledgement goes beyond knowledge, goes beyond, not so to speak, in the order of knowledge, but in its requirement that I do something or reveal something on the basis of what I know. And so I welcome the task force report, just as I welcome all the reports on sexual assault, many of which have been written by college task forces long ago, and like many a university report, were duly submitted and then filed away in some drawer by some administrator only to be rewritten by yet another college task force. Don't get me wrong, reports matter. Universities have been complicit in hiding the number of sexual assaults for fear of bad publicity. We should demand that they be written and that the relevant knowledge be produced. But let us not forget that once we really do know X, we have to acknowledge X. We have to do something with what we know. George Will's problem, in other words, is not going to be solved by producing more accurate facts or buying him a more accurate calculator. There is yet another side to this problem. When formulated in terms of a particular theory of sexual assault, even those facts that we acknowledge can be taken as laying out a kind of road or blueprint for action that may lead us astray. In her marvelous book, Split Decisions, How and Why to Take a Break from Feminism, Janet Halley calls this the prescriptive use of theory. Such use is based on the idea that, quote, any particular theory is a compact, dense mass of valid description, correct normative judgment, and indispensable emancipatory aspiration. So what's wrong with that? Don't we need a little guidance in a matter as grave and as widespread as sexual assault? I shall not try to preempt Professor Halley's talk, but based on her past work, I think I can justly speculate. On the basis of Janet Halley's critique of American feminism, we might speculate, for example, that the search for a theoretical guide in these matters might lead us to think of the problem in almost exclusively juridical and moral terms. These are the terms that underwrite what Professor Halley calls governance feminism. It's a kind of feminism that tends to define gender-based inequality and sexual violence as problems requiring state-centered solutions that expand already bloated bureaucracies and a staggeringly massive and discriminatory carceral system. Governance feminism also has a tendency to get entangled in the very moralization of sexual violence that is arguably one of the largest obstacles to finding pragmatic solutions. A 2012 study at the University of Massachusetts found that 41% of students believe that if a woman is raped when she is drunk, it is her fault. I believe that is what we call blaming the victim. Speaking back to this familiar idiom, however, can easily morph into speaking in its moral terms. The feminist idea of rape culture, for example, though it can be useful for calling attention to the larger societal context in which college sexual assault takes place, can also devolve into a generalized account of men's violent and predatory tendencies qua biological males, and women's nonviolent and asexual tendencies qua biological females. And finally, though not finally, obviously, as one could go on, there is the tendency to restrict the problem of sexual assault within this moralized governance feminism to heterosexual sexual assault, thereby not only ignoring the grave problem of same-sex sexual assault, but also further shrinking the public space in which it can be openly spoken about and effectively addressed. Janet Halley is the Royal Professor of Harvard Law School. She received her PhD in English Literature at UCLA and her JD at Yale. It's a nice combination. She has a very long record of publications which include work on debates in feminism, family law, sexual violence, sexual harassment, and most recently, sexual violence and armed conflict. Professor Halley has also a distinguished record of teaching and service in the area of gender and sexuality studies. Please welcome me.
Hello. I'm delighted to see you here today. I'm going to share some thinking that I've been doing in the current wave of anxiety over campus sexual assault, so the introduction was perfect. The way I want to start this is by talking about a famous case, a rape case from 1981 in the Maryland Supreme Court, arising from facts from 1977 called Rusk against State. And I'm going to lay out what I call a legal realist approach to problems of rule choice in the area of sexual assault, and then use a demo that I'm going to show you in a bit to complicate the problem of rule choice. I'll then jump from rape to sexual harassment as we see it developing today. I'm working off of an article by my colleague Jeannie Sook, who I've done a lot of work in this area with, called The Look in His Eyes, The Story of Rusk and Rape Reform from Criminal Law Stories by Donna Coker and Robert Weisberg. It's a fabulous article, and the first part of my remarks are entirely drawn from her amazing research. I'll be happy to send you all the site if people want to read this. We start with Pat, the claimant, the complaining witness. She was a 21-year-old woman with one child, 2 years old, working as a secretary. She was at the time of the events in question, recently separated from her husband. She's white. She's living with her mother. And she attends a reunion at her Catholic high school. It's a girls' high school in the surrounding suburbs of Baltimore, and and after the reunion, goes out to I think called Fells Point, an area of bars, taverns, restaurants, and nightlife in Baltimore at the time, with a classmate named Terry. The bars that they go to are in a neighborhood that's frequented by local college students, young professionals, working class people, locals, people from the suburb. It's a magnet area where a lot of different types of people are mixing and meeting. Terry and Pat go to 3 bars and order a drink at each one. Terry says hi. Terry, the friend, says hi to a guy named Eddie and calls him by name, and causing Pat to think that this man is known to my circle. That later turns out not to be what Terry thought, or how she testified, that he was a stranger. But at the time, that was Pat's impression. And he comes over and hangs out with them, and they talk for a good while. Eddie, meanwhile, is a 31-year-old National Guard vet. Went into the Guard to avoid the Vietnam War draft, and was out of work. He was had a career goal at one point of being a drug dealer, and I'll get to his convictions later. But right now, his career goal is to open a shop for repairing televisions. He's living, however, off the proceeds of buying cars that he finds in the want ads and repairing them and then selling them. And he is long separated from his wife, or longer than Pat. Pat is very recently separated, but they do have a 17-month-old daughter. The daughter has been adopted by Eddie's parents, and there's evidence that Jeannie found that the wife had drug problems, and that whole pattern just suggests to me, as a family law teacher, that she was either terminated for some abuse or neglect arising from drug use, possibly, or perhaps she relinquished her parental rights to the father's parents. There's something going on there, but it's not clear to me exactly what. The mother's not in the picture. He's living with his parents in his childhood home in a working class neighborhood of Baltimore proper that is spiraling downward. There's a lot of drug trade and a rise of violent crime. And his convictions are for battery, which was for a fight with a man in a bar, and for marijuana possession, and for possessing and transporting marijuana during his aspiring drug dealer days. At midnight in the bar, Pat says she has to go home. She didn't want to be out late, and some conversation occurs about which we have conflicting testimony. And Pat gives Eddie a ride home to a room he rents, not at his parents' house, but somewhere else. And here the testimony begins to diverge quite sharply. Pat's witnesses said that the room was used solely for picking up ladies, which was a term that Eddie and his friends had used for what they were at the bar to do. Whereas the defense witnesses said that he lived there a lot and that it was a home to him. She said to him that this, in the car, that this was a ride and nothing else. Got it? And his friends and he testified that she was hanging all over him and accepted his proposal to go to his place, not to drop him off there, but to go there. What follows takes an hour. En route, she said to him, and this is uncontested, "You're not going to rape me, are you? And you're not going to beat me up, are you?" And that elicited a conversation which he got the information from her that she had been beaten by her husband, and he said, "That's a drag." I'm trying to say that in an affect-free way. I don't know what the emotion of that was. And they arrived. She parked outside. It was in an area that she didn't know, and very near a known unsafe neighborhood. He invited her up, and she said she couldn't because she was divorcing her husband, and there was a very good likelihood that he was having her followed, which would definitely suggest that she anticipated a custody fight in which the husband might charge her with adultery and object to her getting custody of the child. That's standard divorce practice back then. Then we get some more conflicting testimony. I'm still in this bracketed hour. He, at the end of sitting in the car, this is the end, near the end of this hour, I think they were sitting in the car for a while is what it adds up to. She testified that he took the keys out of the ignition and said, "Are you coming up?" and that she felt fear and that she was in trouble. But he denied ever doing that. So now we have testimony that everybody agrees on. She comes up to the room. She goes into the room. She sits on the bed. He goes down the hall to the bathroom. It's just a room, not a separate apartment. And she waits there. And he returns and switches off the light. Now, diverging testimony again. She said she was scared, but not so much by anything as by the look in his eyes. And that's a phrase for which this case has become famous. And she said, again, "If you do what I want, will you let me go? This time, will you let me go without killing me?" He doesn't, I can't see in the report that Jeannie provides of this, the testimony, that he denied hearing those words. She then said that she cried and that he lightly choked her. He denied lightly choking her. And then they had sex. Then his testimony was that that's when she cried, only after the sex, and he couldn't comfort her. And so he walked her down to the car. She wouldn't give him her phone number. She said, "I'll see you around Fells Point." And she left. She drove home, parked in the driveway, thought about it, and decided to report the rape. A rape. She drives to another town, finds a police officer, by about 2, she goes to a hospital. There are tests. There's semen on her body and on her clothes. There's no evidence of any physical damage. And soon after 2 o'clock, Eddie is arrested. The statute in Maryland in place at the time says that rape is the following: sexual intercourse by force or the threat of force against the will and without the consent of the victim. Now, Eddie was convicted at the trial court level. The case was reversed on appeal, and it was affirmed at the Maryland Supreme Court in 1981. And you can see as you go through the story that a very obscure case, this case that the judge, when he first saw it come up to the bench for the day of trial, said, "This is a piece of crap, get rid of it," to the prosecuting attorney. By the time it got to the Maryland Supreme Court, it was a notorious case, and it was well known to feminists who had very strong views about how it should come out. Jeannie gives an amazing account of that. I'm not going to look at that side of it because I want to look at something else. The case got picked up in casebooks of criminal law and is taught widely in criminal law courses in this country. The debate tends to focus on the force, threat of force element. Was there force or threat of force? And the three things that I can isolate in the story as I've gotten it from Jeannie's account are the keys, taking out the keys, the light choking, and the look in his eyes. And the keys and the light choking are denied. So one of the things that this allows teachers teaching the case to do is to say, suppose the jury didn't believe those two pieces of physical conduct that could be deemed to be threats of force, and convicted Eddie on the basis of the look in his eyes. And that turns into the following question for pedagogy, which actually was important in various ways during the whole trial process. Can subjective fear, this is a way it gets translated legally, can subjective fear alone satisfy the threat of force requirement? And if it does the threat of force have to be objectively reasonable? Would a reasonable person think that that set of behavior was a threat of force? And so I'm going to hold on to those questions as framing questions for the talk. One of the things that happens when you see this case discussed among students and actually among colleagues in reading groups, wherever it goes, is that people interpret the facts very, very smartly to confirm what they come into it believing to be true about whether rape is over-enforced or under-enforced. So the students in the class who are arguing that we need expansive rules for rape enforcement will will interpret the case even without the keys and the light choking to be highly coercive, and they're very good at doing that. And the people who think rape is a claim easy to make and difficult to disprove, though the accused be never so innocent, Lord Cook, many, many years ago, interpreted as this guy got framed. And here's why, here's why, here's why. And so the discussion in the classroom becomes about, which of my interpretations is right, as if the act of interpreting from the premise that you prefer is the thing that proves your premise. I don't really want to do it that way myself. So the thing that I want to show is, presentation is hidden. I think if I hit that, is a chart that I've made. Can you guys see that? No. Okay, that's okay. I will interpret it for you. What this chart says at the top is state against Rusk, possible ideal types. And what I've done is I've taken the story of state against Rusk as it comes to us from these materials. And I've tried to figure all the different possible Pats and Eddies that could exist if all the people who interpret it are right. Not just some of them, but all of them. So my practice, you're right, that is quite teeny. The idea is to develop ideal types out of different Pats and Eddies that encounter each other along a spectrum of Pats and Eddies. So I'll tell you what it says. What you have to imagine is that the top row is the Pats, and the bottom row is the Eddies. And I've put them in a range from the most sympathetic to Pat and the least sympathetic to Eddie on one end, and the most unsympathetic to Pat and the least sympathetic, the most sympathetic to Eddie on the other. Okay, so it's a spectrum from 1 to 5, and what we have is Pat Pat at Station 1 was a rational interpreter of what really happened, and we all agreed that it was a real threat, and that she was rational in permitting him to rape her, that was a choice we think that we want to allow women to make and still make a claim of rape. The next pat over is a little more complicated. She's a Catholic schoolgirl who is naive and clueless and stumbles into a bar and is in over her head. And I'll get to the different eddies that she might meet there. The next pat over is quite emotionally volatile. She's projecting wild, crazy projections on Eddie. Will you kill me? Will you let me go? Despite the lack of being prompted to have such a high level of fear by the actual situation. The next pat over, still less. Actually, this is a pat I feel a lot of empathy with, actually, but legally possibly less reliable. She's ambivalent about between desire and flight. She's tempted to have sex with this man, and she thinks this is something I shouldn't be doing and I can't be doing, and this isn't me. And she wants out of there. And in retrospect, there's a remorse thesis about her. She feels terrible about it afterwards, and decides that she either feels guilty or confused and has a sex panic and transposes the guilt from herself onto somebody else. And this person is in perfectly good faith when she accuses rape, I'm positing, but she's not living the examined life, let's put it that way. That's what the chart says. And then the next person over is a scheming liar. She has a child custody motive to deny that she had sex that she wanted, that she went for, and that she did have, and that when she was sitting in the car in the driveway, she cooked up the idea that in case she was seen by the detective, she could put all the responsibility off on Eddie. Okay, who are the Eddies? The rational interpreter Pat, the most sympathetic Pat, the most legally plausible, legally reliable Pat, classically meets an out-and-out thug who wakes up every Friday morning and thinks rape day. Intends rape, means rape, plans rape, performs rape. I believe these people do exist. The next one over, a little more sympathetic, is a lower working class guy living in the shadow economy, and he's reckless about the lack of consent. Not intending rape, but reckless about it. He doesn't know that what he's dealing with is a Catholic schoolgirl who's naive and in over her head. The next one over is a lower working class guy living in the shadow economy and used to working class girls who push back harder. And he's not used to somebody who gets who gets so afraid. And he misses all the signals, and then I'm putting this into the account because of class incommensurability between their class understandings of how men and women who go to bars interact around the possibility of having sex. Or how, as I put it on the chart, how women signal consent. The next one over is the same lower working class guy living in a shadow economy who got all her signals about desire and interpreted them according to his own value codes. He got those waves of yearning off of her. So he was watchful. He got some of her signals. He understood part of her subjectivity, but he didn't get it in this case. He didn't get the dark side of her desire, the fear and flight impulse. And then the next Eddie over is totally innocent, and he never took the keys, and he never choked her. And so what I say with this chart to people talking about this case is quite a few things. The rule that you, okay, notice the little lines that go between Eddie's 1 and Pat and Eddie 5. That suggests that I think that the classic meetup that probably happens empirically, if you could know anything about this, quite often would be the meeting of the scheming liar with a totally innocent guy, or at least conceptually those are kind of interdependent. A scheming liar would finger a totally innocent person, or the schemingness of the lie makes the person innocent, or I don't know, let's talk about that. But, and at the other end, an out-and-out rapist is going to run into a lot of perfectly unintending people who give in to threats, and we want to support their decisions to save their lives. But in between, very clearly, all those people in the middle can mix and match quite readily. Any of those can meet anyone. In fact, any of them could meet any of them. And my point as a legal realist is that when you choose rules about rape, you have to be aware that you're not, unless you're going to only be an advocate, if you're going to be a governor, if you're going to pick rules for running the system, you need to, your rules are going to apply to all those combinations of people. That's a different view of the case. The next idea that I bring in through this chart is the idea of the rule tick. And what I mean by a rule tick is that rape law is a series of nested and parallel and ancillary and rules. There's lots of rules. And you can tick them so that they get you more convictions and get you more acquittals. And if you thought that the world was made up of only Station 1, out-and-out thugs who set out to rape on Friday, it's rape day for them, and rational interpreters of fearful, fright-inspiring signals, you would, and then the rule that I picked was a subsidiary rule to the question of subjective belief. In a case of subjective belief, again, in a case where our question is, should we rely on subjective belief and subjective belief alone to supply threat of force, a subsidiary rule might be what would be the evidence we would want. And so just to simplify, I say, well, if the world were made up of only those cases, you would always believe the woman's testimony. Right? That's what that bottom box is on the column 1. And but if you believe that all you had was scheming liars with child custody motives and other reasons to deny responsibility for their sexual engagements and totally innocent men, then what I put in that box was you would believe the women in these subjective cases only when you have 3 witnesses, a rule that I kind of picked up out of Islamic law and dropped onto my chart. The question of, well, we could tick that rule back and forth in between in a million different gradations. For instance, a middle position might be to say, well, we'll believe her, but only when it's reasonable to do so. Like that's when you would add a reasonable person requirement onto the belief in what the woman says, uncorroborated testimony. Okay, before I go on to even further complication, I thought I should stop and just take questions about this, because how many people in this room are training to be lawyers? Some. So how many have studied Rusk against State in criminal law? Some. And so many people are not. I'd love to just, before we go ahead, make sure that despite the visual failure of my chart, that the concept of it got across, okay? Or anything else about what I've been saying so far. Yes, in the back.
I was curious if another factor in the spectrum had been taken into account in terms of prior sexual trauma, in terms of it being not necessarily projected, but taken into account in terms of, say, she had been sexually assaulted by her husband, but it had been an abusive relationship, and she was in a situation that she suspected was similar to or was about to happen to her.
Yeah, some people have argued that it shouldn't be reasonable person, it should be reasonable woman, or reasonable woman with victims' experiences, and those are attempts to re-subjectivize the objective, and to historicize that into the test. So those discussions definitely do come up. Yes. Anything else? Yes.
Was there any effort to look at his pattern of assaulting women?
There are the 3 convictions for non-sex related things. There are no other convictions. There's no other record of, Jeannie looked all over, there's no record of any other accusations against him that she could find. And she interviewed everybody who was still alive involved in the case, and none of them had any other information on that lines either. So no. No, the Innocent Eddie story is that he was a ladies' man and liked to pick up girls. And, was shocked when he was arrested, just blown away. Okay? I'm trying to capture the sensibility there. So although, when you teach the case or you sit in a reading group and people are interpreting it, they'll naturally think, lower working class guy, living in the shadow economy, goes to bars and picks up girls, probably a serial rapist, or a serial reckless guy, or a serial negligent guy, right? And so I'm trying to frame that. I'll get back to that piece in a bit. Okay, so I think we're all on the same page. The rule that you pick applies to all the cases. Now, at station 1 over there, where you believe all the women because there are intentional rapists and rational women subjectively deciding to give in to them, the rule, if it applies to all the cases, you pick the rule because of that, the rule will apply to all the cases, including Station 5, and you're going to throw a lot of innocent guys in jail. Sorry. But that's true, and you have to deal with that. I think one of the things about being a governor is, can you sleep knowing that you have made a rule tick choice that will increase the likelihood that you will be putting some innocent men in jail in order to capture more of the cases at the end of the spectrum that you think are escaping review. And that leads me to Station 5, bringing in 3 witnesses. That might be good for the cases where we have scheming liars and totally innocent eddies, but it's going to get you a lot of false negatives. It's going to let you get a lot of people, men at Station 1 who do serially rape, men who are reckless, men who are negligent, and so forth, are going to escape punishment. And in my part of the world, in critical legal studies following Duncan Kennedy's great article, Sexy Dressing, we call that the tolerated residuum of abuse. The tolerated residuum of abuse, that's the gap between 12% and 20%, or whatever the gap is, the tolerated residuum of abuse. I mean, I question that 25% number, by the way. I don't think it's a good number, but we can get to that later. But one of the things that we think is that the tolerated residuum of abuse is not only bad for the women who don't get their convictions or don't bring their rape cases, but it's bad for a lot of the women, if not all the women, because it makes the general society more dangerous for all of us and makes us curtail our lives. My figure that I like to think of at this point is, way far from rape, a woman is sitting at the kitchen table alone, unhappy in her marriage, deciding whether it's time to end it. And it might cross her mind to think about how dangerous it is to live in the world she lives in without residence with a man. Can she hack it out there on her own? And if she ever does, then the tolerated residuum of abuse depresses the divorce rate of women who would otherwise choose to divorce. So it has pervasive effects, just as putting men in jail might have pervasive effects on men. Putting innocent men in jail, I'll go back to that. the effect of putting innocent men in jail, what would that be? I think that we have to face up to the problem that it is problematic to put a lot of innocent men in jail, even if you're with Station 1 kind of thinking, because what this does is it creates victims of the rape enforcement system and delegitimates it and gives people the animus to push back in the legal system. Now, there are some feminists who think, I want to do that anyway. I want all the good men to be scared. I want, and they'll say this, I want some innocent men in jail, but very few will. Most don't want to. Okay, another few points about this spectrum. It's not just about men and women. The Russ Against State facts make it clear that it's also about class. The encounter of what I'm positing is a Catholic schoolgirl from a middle-class family with a young 31-year-old man from a working-class family who's really living hand-to-mouth in the shadow economy is going to be a clash. Is going to be a class encounter as well as a sex encounter. And there, another point, the encounter is a semiotics that law intervenes in and helps to manage. The middle range of my spectrum is about the social semiotics of state of mind. What should we say Eddies must understand about Pats? And if there is an incommensurability of class language, whose view should the state adopt? Is it the state's view that working class men are entitled to expect women to push back because that's what they're used to, or should the state adopt the view that middle class girls should be able to go to bars and meet working class men and bring their sexual semiotics with them? So that's another piece of it. And finally, it's politically contested. There's pressure both left and right to go in either direction on this spectrum. Let me tell you some pressures towards 3 witnesses. There is a right-wing version of wanting 3 witnesses. It is the reason why rape defense lawyers want women on juries. The thinking goes like this, something like this. Women should enforce strict sexual morals and withhold sex more often. They should withhold it to marriage or until they get into long-term relationships, at least where the man will pay for the sex with some shouldering of responsibilities. And women with weak cases, women in the middle of the spectrum, certainly women at the end of the spectrum, are very likely to almost, some of them are, defectors from the basic sex strike that morally good women are imposing on men generally. And we shouldn't use the legal system to let them order the social world to their liking. This exists, and as I say, rape defense lawyers do look out for the women jurors who will vote for acquittal for these very reasons. There's also a left feminist version for going for 3 witnesses, and that is certainly by the time you get to scheming liars, but maybe also where you get to ambivalent people who aren't living the examined life and want to push the cost of that off onto other people. That feminism might say, these women are not my sisters. These women are not the people I'm doing feminism for. I'm doing feminism to promote women's sexual autonomy and a rich array of sexual spaces and sexual choices. And I'm not into a repressive project like Always Believe the Women, which brings me to the left and right points that I want to make about always believe the women. There's a left and a right, many left and right, but I'm going to just bring out a couple. A right and a left reason to always believe the women. One, pure social repression. Too much bad sex, use the criminal justice system, punish and deter social control. Get good social order through an expansive use of the criminal system. And there's a left version of Believe All the Women, and this goes back to early days in legal feminism of my generation of women and next generation up. You could call it standpoint feminisms. You know, women have experience. Their experience is the thing that feminism is here to unearth and to give value to and meaning to and recognition to and room for. And when women say that they've had sexual injury, we should start out by believing them. Maybe until we have good reasons not to. Maybe we should just believe them. And then here's the thing that is going to be very controversial, and a lot of you won't like this, I bet. But I think that there's an interesting new form of feminism that is grown out of that standpoint feminism, has also grown, but has moved in that rightward social control direction and is becoming more politically conservative. It's flourishing right now, and it has the following characteristics. Social control, extreme high priority, explicitly repressive, zero tolerance, fine with them. Innocent men in jail, not a problem. In fact, they're probably not innocent. One of the things that they do when they hear that that Pat had the child custody motive, this will happen in your discussions, they'll say, well, you know, the only reason she has the child custody motive is because of a husband, and that means that the husband and Eddie represent male domination. She's just scrambling around like anything, trying to find a way to live under conditions of male domination. So she lies, you know. And what's the big deal? It's really male domination all across her life. And I don't take it seriously that she lied. She's dealing with male domination at all times. There's a strong commitment in this discourse. It is a pretty new feminist discourse that it says it's very much with civilization against eros. I have a reading group that is full of these feminists, and when I suggested to them, you know, well, maybe there's seduction, you know, seduction, and you know, the uniform sneers all around the room, you know, seduction, you know, that's just another word for men, you know, weaseling their way in, weakening women's sense of what it is that they're there for, you know. And so, you know, there's that strikes me as a kind of suspicion of eros. There's somehow a cabining of it. It's not part of this project. The most sex is unwanted and harmful to women. Women need protection even when they don't want it. This is the branch of feminism, for instance, that wants the prosecutor to prosecute even when the woman doesn't want to be a complainant, or wants mandatory reporters even when the people involved in a case don't want to bring them forward, and so forth. Although that in particular, that one is largely motivated by liability concerns in the sex harassment context, and so, you know, this is a package of ideas that is more powerful these days, and I've been struggling with ways to understand that it overlaps a lot with social conservative, social control visions of sexuality. Okay, so I'm going to now talk about some legal phenomena, and then I'll be done. So maybe I should stop now also and just see if there are any clarification questions about the complications I've just laid on my 5 stations. These would be kind of clarification questions. We'll have discussion. Okay, so let me talk a little bit about two sets of rules that have moved the question of women's subjectivity quite a bit over the history of rape law, over the longue durée, and then over sex harassment law only in the last 15 years. Okay, so then I'll be done. The starting place would be rape, Blackstone, old English law, common law. Blackstone, the rape is sexual intercourse by force, but the woman has a duty, and against her will, but the woman has a duty to resist to the utmost and a duty to flee or attempt to flee. Now, Ann Coughlin has a very interesting article that doesn't actually prove, but makes a really good case, that the reason for those very unforgiving to the victim rules was that when they were written, well before Blackstone, rape was not a charge so much as a defense, and the charges that it was a defense to were adultery and fornication. So a woman would end up pregnant, she was signal, a woman would be married, she'd be caught in bed with another man. She would say rape, and the legal system would say to us, it has to be by force, and you have to have resisted to the utmost, or we are going to hold you liable for adultery or fornication. That's Anne's understanding of why we're very unforgiving. Once you've actually committed the conduct we prohibit, to let you get an excuse, right? So this would be an excuse, and excuses are narrow. So anyway, that's way back there. The more modern form is by force and against her will, which substitutes for resist to utmost and duty to flee. And then the more modern form of that, so you have to have a will against it, okay? Then the next one is by force and without her consent. The next tick historically was by force or threat of force, or without her consent. Now this formulation meant that if a woman was faced with a man with a knife who said, "I will cut you," or have sex with you, you pick, and she said, "Okay, then it's sex," she has consented, right? So the next tick over was to go by force or threat of force, even if consented to, no longer a consent element. And this is the trend in the revisers of the model penal code seem to be going in that direction right now. We're now in the zone of the governance feminism. We're now in the zone of actual feminist influence on law. There was a big blow up about this in Rusk, that I didn't go into, but rape, self-defense training was then saying, give in, don't fight it, much safer, and feminists were arguing that the law should not penalize women who consented. And that would be the rational woman whose consent, we want her to consent so that she'll live or not get severely injured, some formulation like that. But then the new thing that's happening that I think requires some explanation, I think I may have it, but this is just me trying to put the pieces together, and I'm going to offer it to you, and this is the first time anybody's heard it, is a move towards the affirmative consent. There must be affirmative consent, California statute. There must be affirmative consent, or it's unconsented to, and that's the current wave. That's in our now time, and then you increasingly, even in the context of rape, begin to hear something new, and this is what I'm going to try to explain to you. You begin to hear, not by force at all, not requiring affirmative consent, but merely unwanted or unwelcome, even if consented to. When I ran it by this group of feminists that I have in my reading group, what do you think of the California affirmative consent statute? They all said that gets us nothing, because the women consent to sex all the time because of the coercive conditions of male domination that are pervasive in everyday life and are pervasive on campuses, and they consent to unwanted sex. And the problem is the unwantedness of the sex. And so there's now a very corrosive feminist critique, even of affirmative consent. Do I have you with me? Now, one of the women in the room said, "Oh, that is I would be fine with rape being a strict liability offense." That I would be fine with rape being a strict liability offense. What a lawyer hears when they hear that is what is the law in Massachusetts. In Massachusetts, the man doesn't need to know, doesn't need to intend that the non-consent. If it's found to exist separately, that's enough. It doesn't need to be part of his intentional mens rea showing in the case. But there's still a force requirement in Massachusetts law, and the force requirement has an intent requirement. What the students mean is that these students in my group mean that the entire unwantedness of the sex should be a strict liability offense. Now, that takes things pretty far. And I've been trying to figure out why does that, where did wantedness and unwelcomeness and this suspicion of consent get kind of discursified, get locked up into a block of thought that could be moved around and used. And my proposal is sex harassment law. I'll give you just a totally quick rundown and then I'll stop. Sex harassment law as it is now discussed, and as it now exists, not in your campus policy, but in my campus policy, is the overarching term and includes sexual assault. Where did that come from? Okay, so it makes a big deal to me whether there's sexual assault over here and sexual harassment over there, or whether there's sexual harassment over here and sexual assault is a type of sexual harassment. And what we have in the Harvard policy is that, and what you guys have is here's sexual assault and it requires force, and here's sexual harassment and it's something else. I read your policy. And what's that about? Okay, here's what I think it's about. Our original position in sex harassment law started in Title VII, which is an employment law. It covers sex, race, nationality, religion, blah, 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 blah. And it's anti-discrimination on all those grounds. And it governs employment of employers over a certain size. And the original idea, the thing that had everybody totally lit, was Anita Hill and Clarence Thomas type interactions. Workplace interactions where bosses would hit on subordinates and would impose themselves sexually, maybe by requiring sexual favors as part of the job, maybe by just swamping the woman with unwanted conduct and ruining her job, okay? And so that was what it was originally. And there were three elements to the original claim of sexual harassment. They were unwantedness of sexual conduct, unwanted sexual conduct that was sufficiently severe or persuasive, I'm paring down a little bit, to interfere with the woman's work life, okay? And all of that in the case law under Title VII is subject to the objective reasonableness standard, objective reasonableness requirement that I've been telling you about. So unwanted, some courts say, was it unreasonably unwanted? Was it severe or pervasive? A severe episode could be a single episode. It needs to be not just that the plaintiff said it was very severe for me, but objectively severe, and interfere with the workplace environment. Not, wow, I was really destroyed by that, but a reasonable woman or a reasonable faculty assistant or a reasonable graduate student would be completely destroyed by that, or not really completely destroyed. The question is interference with work. So that was where we started, and that's where things stood before this current wave of campus sexual assault activism. And then along came the DOE-OCR, the Department of Education Office of Civil Rights, it has issued 3 documents, one on the last day of the Clinton administration, in which it held to this formulation. So that document is from the DOE-OCR, but a former administration. Anything issued from the last day of an administration is a love letter to the next administration from the same party. It's going to just sit there until that same party comes back. And so that was Clinton's contribution. It was traditionalist. But the Obama DOE-OCR has done some very dramatic things in what is called a Dear Colleague letter from 2011 and a question and answer document from this year. And in those documents, it reduces reasonableness to a factor. Now, lawyers think this is a big deal. A reasonableness requirement is something you have to look into. A reasonableness requirement is something you take into account, is something you take into account and you weigh it with everything else. So it's demoted to a factor. And in a settlement agreement that the DOE-OCR has reached with the University of Montana, University of Montana under investigation, like my law school, like my institution, for violating Title IX. It makes a settlement agreement with DOE-OCR and DOJ very recently. And in that, the DOJ and the DOE-OCR say, it is wrong that sexual harassment has a reasonableness factor, or even that it interferes with the workplace or the student environment. The unwantedness alone is the harassment. So that seems to me the fullest tick of this rule block over. The question will be, there are many questions raised by this. If we had a lot of Pats and Eddies on campus, what would we do to set up an ideal types for campus? And how would these rules work given the tolerated residuum of abuse that works, the false positives that you get out of believing the women, the false positives you get out of widening the definition, the fact that many women never bring their complaints. All of that is now up for grabs under a rule system. Now, last point, and then I'll stop. In those places where we take the DOE-OCR's framing, sexual harassment is the overarching form and sexual assault is merely a kind of it, that's going to be the place where sexual assault law begins to absorb unwelcomeness as the wrong, rather than, and loosens up its hold on its traditional insistence on force or the threat of force. That, and my diagnosis, which I can't prove today, but I believe it, is that that's why even in sexual assault discussions, you're increasingly hearing it was unwelcome, which is bizarre, okay? Okay, there. Not bizarre policy-wise, but it's a social surprise. Okay, there. Okay, we have time for questions. There's a lot of law. Yes, your name?
My name is Morgan, and I just want to pick up on something that you said. You said that you disagree with the 20% number. I'd be curious why.
It is invoked to say that 20% is the number of sexual assaults or even sometimes claimed to be the number of rapes that occur on college campuses. The studies, sample size very small, very difficult to get people to answer the questionnaires. Lots of things you can say about the methodology. The thing that I think is most key is that the questions include in sexual assault unwanted sexual conduct that you engaged in while too drunk to have a complete control over the situation. So the very thing that we're contesting is included in the number, okay? So the number almost begs the very questions that we should be debating, I think. So yes, if those sample sizes are good and if the other things about the studies are good, all of which can be challenged, the idea that the baseline is 1 in 5 assumes what it's then used as empirical evidence to advocate for. I'm sorry, but yeah, in the back. Yes, in the tweed coat.
I was surprised by something you said, and I don't mean to sound defensive. I've been away for a year, but until then, I served on and chaired the college discipline committee, which heard sexual assault cases. And we heard way too many of them. And perhaps we haven't read our own regulations, but force was never an issue. We never considered it. We never considered threat of force. The only thing we considered was their consent and was a reasonable man to believe he had consent. So maybe we didn't follow our own policies, but that's what we did. And I know the university is under a Theory Act, right, investigation, so I'm not trying
You
to
are?
defend what we did.
Didn't know that.
I'm just confused.
Okay. New policy, July this year.
I've been away for a year. So.
And sexual misconduct is the rubric, and it includes sexual harassment, sexual assault, domestic violence, dating violence, and stalking. And each of those is defined separately, and although I'm not necessarily going to be able to find them right this minute, the sexual assault and DV and dating violence and stalking, let's see. Dating violence means the use or threat of physical, mental, or emotional abuse or sexual violence. Okay. Let's see. Sexual assault means an act of sexual penetration or sexual conduct by the use of force or threat of force. So what's happened, I don't know, it'd be interesting to compare. Pardon me? Anybody know?
No, not that part of it.
We'll have to inquire into this. I thought that one of the things that was useful about the framing of the document that I'm holding in my hands right now, it's called University of Chicago Policy on Unlawful Discrimination and Sexual Misconduct, is that sexual harassment is distinguished from sexual assault, and it allows for a ranking of offenses. It allows for an explicit acknowledgement that violence, the threat of violence, the use of abuse to obtain consent, those are serious and there can be, there's also some you guys still have reasonable person in your definition of sexual harassment. There's lots of ways in which your document doesn't take just down the DOE-OCR road. I just thought it was really quite remarkable. Whether you guys are happy about that, I don't know. I'm currently arguing at Harvard that we should be more like you. But that's just my own politics. Okay, other questions? Yes. And your name, I'm sorry?
I'm Jerry Rosenberg.
Oh, hi. Okay.
Hi, my name's Emma. I was curious about your use of the terms eros and seduction and was hoping you would clarify a little bit what you meant by those.
Yeah, sure. I mean, I was Eros and Civilization, famous book by Sigmund Freud. The idea that sexual desire is a dark and subversive form of human engagement with the self and others and with inside the psyche, that there are deep impulse drives to it, that it vitalizes the situation, it's Dionysian, it's exploding with life, and if let loose, it would bring down civilization. None of us would do anything all day except be fuck. And nobody would get any work done. And if we can't have that, so we bring civilization, and civilization, and this is the kind of what people call the repressive hypothesis, has to kind of take that drive and cabin it and get us to wear some clothes, you know, and sit in rooms and study and, you know, and do things that aren't about that, and build a civilization, follow rules, and, you know, so that's what I meant by that. And I love them both, but you know, both of them can be extremely dangerous, right? I mean, the idea is that neither of them is entirely a bright note on the human landscape. And the other so that's what I meant by that. I meant good and bad in many ways. I was saying that I think this new conservative feminism has a suspicious relationship with Eros, as I just described it. It is not at home with it. And there are forms of feminism that are very much at home with it. So that. And then seduction, seduction would be the project of tempting another person who now doesn't want to have sex with you to become so wrapped up in the idea of having sex with you that they go from not wanting it to wanting it. And when I said that to my reading group, I said, but what about seduction? They thought, you know, it's almost like that's stealing women's souls. You know, that's taking away their will. That's undermining their integrity. Well, yes. I mean, successful seduction messes things up, but good. And so, you know, that's what I meant by seduction. It's about converting unwantedness into wantedness through. I'm not going to tell you how. And so, but you know how, you know, and in fact, you probably couldn't put it in words and wouldn't be good for civilization if you could. Okay, there. So is that helpful?
Yes, thank you.
Yeah, sure. Yes, Linda.
So, okay, let me frame this by saying that I think I see where you're going with this in the sense of the sort of continuous erosion of women as subjects who are even capable of consent. All right? I mean, in other words, that's really, in many respects,
that's what's heaved in.
Let's go back to the 19th century, let's go back to coverage, let's go, you know, women can't even give testimony, they can't even, that's sort of the direction that we're headed here. And I am as worried about that as you are. I'm on the, you know, the Eros bandwagon and all that, that's fine. But what I would like you to explain is why the position you're arguing for would not land us in the kind of position that, frankly, someone like George Will is arguing for, okay? And I think that there are some really important nuanced differences here, but I would just like to hear you articulate them because, of course,
right.
He's all about consent. He's all about, you know, women should, I mean, he would take the University of Chicago's policy, whatever the hell it is, and he would probably say that that's just fine, let's keep these things separate. But it's not like the policy is working for us either. So is it a problem in the policy, which now we don't really know what it is, but if we did know we do know it's under these two different umbrellas. Is it a problem in just the implementation, but in fact the basic concepts of consent and force and the rest are still okay by your standards? Or is it that, you know, we need to really rethink under what conditions can we even say that a rape has taken place?
Great question. I do think that we have to put some innocent men in jail to reduce the tolerated residuum of abuse. And I do think we should reduce the tolerated residuum of abuse. I don't think you can avoid putting innocent men in jail when you go off to do that. That's how a legal order works. We don't try for truth, we try for conviction or acquittal. And even in a criminal case, it's beyond a reasonable doubt. Now it's preponderance. We're not asking for truth, we're asking for an approximation. We're running a system. And as you shrink the tolerated residuum of abuse, your rule ticks are going to put more innocent men in jail. I think that's regrettable, but to some point worth it. So I'm not like George Will, who just says, wow, innocent men in jail, stop. Everybody stop. This whole thing's broken. You know, you've just got to stop, and start disbelieving the women and go back to the way it was and inevitably, you know, kick the tolerated residuum up to original levels. No. I think we need to shrink it. I think we need to face as good governors that we will put innocent men in jail. Or kick them out of the university. And so I just think that's just, as I say in Split Decisions, that's just being a feminist who's willing to look down on the blood on your hands and just say, yep, I was willing to do that. It was worth it to me. Now, one thing I would say, though, is that this whole discussion, and George Will's article, as you represented it, I wasn't aware of it before you brought it up, assumes that the only tool that we have on the table is criminal enforcement and criminal enforcement-like practices like sexual harassment enforcement that has serious punishments attached, like kicking you out, you know, kind of the equivalent of death penalty for the community, from the community. You're gone, you're out. I don't think that. And I think that if you would set up a Pats and Eddies for the problem of campus sexual assault, if we would get past our rhetoric and not spin so goddamn much about what everything is, and admit that some of these cases are in a semiotics that require a lot of unraveling, we might be able to talk about the differences between different kinds of settings in which we're seeing women coming out of them and saying, I had unwanted sex and I want somebody to do something about that. What we're now saying to all those women is, here, get the individual man who did that to you punished, and we will assist you with that. But that seems to me a little bit like, you know, trying to, you know, the expression that comes to mind is kill your way out of Iraq one enemy at a time. It's a criminal enforcement model. It depends on individual responsibility. It lacks a public health vision of what the problem is about. And it lacks an idea that we could all cooperate in creating spaces that were really, really cool and competed with the parties or the dating relationships or whatever it is that's generating the complaints. But to do that, you'd have to stop spinning the stories all the time and figure out what these parties are about. And so one of the things that I'm telling my students is I'll supervise a paper. We'll go and do participant observation at you know, final club parties, you know, and come and tell me what goes on at final club parties, and we will write it up. But you know, the spin that comes out of those parties is just unbelievable. How much of those parties, those are equivalent of fraternities, how much of those parties are a problem? Can they be made less dangerous? can we deal with you guys have a thing called domestic violence in dating relationships. Those are different from drunk cases arising at big parties. They're different from that. And we would have to put them on this thing and, and see how the rules would work on them. But I would definitely suggest that punishing at one individual at a time is just, it's a pure deterrence, punishment, and social control model. And it can do some things for you, but it can't do all it's cracked up to be. And we should be thinking in more positive ways. So yeah, I would say, I'm not George Will. I don't know if that's satisfying to you, but I think that a funny thing has happened as feminists have gotten more and more of a hold on the state, and that is that they've fallen more and more in love with crime and punishment. And I think that this is working against some left liberal trends that we may have gone too far with crime and punishment. So the plea is to think about other ways of imagining a healthy sexual and non-sexual life for women on campus. I'm not saying women have to be sexual. It's okay with me if they have nothing to do with it the whole time here. But if they don't, they should have a great time, and if they do, they should have a great time. That should be the question, not who are our bad men and how can we figure out which one should we kick out. Okay, so that would be the kind of spin that I would want to see put on it. Okay, anything else? Kind of, yeah, Lauren.
My question is sort of formulating, so I hope it's okay. I hope it's okay if I try it out. Which is, I really am interested in you talking about what you think the ideal relationship is between a university set of protocols and procedures for managing events of sexual harassment or violence,
Yeah.
and public juridical model of that. Because one thing I've been really struck by when I'm reading this summer is people saying people choose the university protocol, that is to say people who have had bad events, unwanted events, have choose the university protocol because they think it will be more humane than a public juridical protocol. That whole, it just strikes me as an insane situation that we're in, to have two quasi-legal and legal systems at once adjudicating something, and where there are, at the university, it's all hyper-private. I mean, you don't know who's on the committee, you don't know anything's happened. It's very...
Lots of confidentiality.
Yeah, it's super confidential. I'm not saying that as a complaint, just as...
No, it's a real problem.
It's more public if you use the public law. Anyway, I myself am in a kind of, in a phase of trying to develop an account for what I think the relation is between what a university should do and what the law should do, and what we should encourage, and the question of what individuals who are, in a certain sense, informalizing the event within the university do in relation to a public juridical model of crime that you, I am with you, can be overused. And I'm happy if you want to respond to this by saying, here are the 10 problems I see in this, without having a clear idea yourself.
Yeah, the DOE-OCR has been directing campuses to work more closely with law enforcement and has been producing a more and more law enforcement consciousness in the campus sexual assault domain. And yet campuses, though they do have their own police forces, the disciplinary process is traditionally something else. It's about maintaining, should be, I think, about maintaining the academic values of an academic community and the well-being of all the members in it to participate in that academic community. I'm not surprised as a lawyer, Lauren, that there would be two legal systems operating simultaneously using a lot of the same language on the same cases. That's very common legally. And one of the things that you get good at if you come to law school and you find you're enjoying your time there, is because of the inherently hilarious nature of having this plurality of jurisdictions operating and doing crazily different things. I mean, nothing is as funny as conflicts of law, which is the body of law about what happens when two jurisdictions disagree about what law applies to a certain case. Very hilarious. And there have been many plural legal orders. The Ottoman Empire was a plural, this is becoming more like one. It used to be that campus discipline was really about academic community, and there was the law enforcement over here, and this whole thing is bringing them into a comparable frame, and ideas are moving back and forth between them frame, and they're actually being required to cooperate more. The answer to your question could go on for a very long time. I'll just say it's fraught. For instance, if a campus sexual wrongdoing accused person fears filing of criminal charges, that person is very likely to be told by their lawyer to not defend the campus case, because of the fear that the university will hand over all the records of what they submit in the case, and the transcripts, if any, and the statements, and to the law enforcement. Universities often fight this, but there's no guarantee going into it that they will. And so this simultaneity of possibilities and it means for that little intersection that the discipline boards are facing the problem of defendants who fold, and I don't think they've quite caught up with this. They haven't figured out how to develop an advocacy project for that person so that a defense is offered. So I think that the interaction. So it's at that level that I'm thinking of it, Lauren, right now, is that the interactions are very detailed and very perplexing. And very intricate, and new. So I can't give you one single answer to that question. It's an evolving story.
But do you have a desire? Like, if you were the boss of everything, like, would you know what kind of relation you would want to have set up?
I mean, is it better for universities to handle it?
I'm asking you. What do you think what do you think the function of this double juridicality could be from the perspective of quashing erotophobia, atmospheres of sexual violence, but also doing justice to the people who are claimants?
Yeah, okay, let's suppose we started with a campus discipline system like the one in this document that I wonder, it has three things short of a formal complaint process. It has informal resolution, it has professional mediation, and then it has an informal process, which is more formal than informal resolution. Informal resolution can only be reached by the parties. Mediation, similarly. Now, those are processes where you could bring in all the guys who give the rapey party, and you could sit down with them and say, let's solve this problem. And so I like seeing those ADR, alternative dispute resolution elements in your policy. You may not, because they're not sufficiently punitive, but I think they could be quite creatively used. And the trouble with the law enforcement is all it does is prosecute. That's all. And its goal is to put some people under conviction and possibly incarceration. So that is a very powerful tool, but it's also a very partial tool, see? So I think my general attitude is to be unhappy to watch law enforcement consciousness coming on campus. I think probably we could do better if we tried to think about it from a campus perspective. But I admit I'm really at odds with a lot of feminists on that.
I think we have
guys for some great questions.